Good morning, Ms. Burton. You have 10 minutes.
Yes, Your Honor. Thank you. May it please the Court. Carolyn Burton, appearing with Robert Bonsignore on behalf of the plaintiffs. The first issue I would like to raise with the Court is the substantial offer of proof the plaintiffs made at the lower court to prove that they could demonstrate liability in this case without reference to the payroll records.
Well,
Despite acknowledging...
That seems established beyond a shadow of a doubt. You've got internal memos, depositions, all kinds of evidence out of the mouths of all the Wal-Mart executives, store managers, and others that they knew this practice was going on, that they were altering store records, that they covered it up when they were hit with a $500+ million lawsuit in one of the states, including, I got a Wal-Mart about a mile and a half from me. The store manager was deposed in this, and the assistant manager, and they said this was going on.
Despite that evidence that we tried to brief for Your Honor and to put before the court expressly made several rulings of error. The first is that notwithstanding that evidence, in addition to the store-wide evidence that we proffered, that we would fail at our burden at trial. We could not prevail at trial. The court expressly held there is no expectation that the plaintiffs will provide the kind of comprehensive representative testimony allowed by DeSisto or a close substitute. We believe that it's an error for two reasons. One, it is not factually supportable. Number two, it's the wrong standard. What the court essentially did below was require us to meet our burden of proof at trial when the trial had not actually commenced. This court has repeatedly said that the standard is whether or not plaintiffs provided sufficient evidence upon which the lower court can make a reasonable judgment that certification is inappropriate. Now, because we've briefed the evidence for Your Honors, the corporate evidence...
Do you agree with me that whether or not to accept the evidence of your expert after the Daubert-Lanigan hearings, we review that on an abuse of discretion standard?
Your Honor, I do not agree with you. As we briefed here, these issues concern legal matters, legal questions, burden of proof. This is not a typical...
The admissibility of an expert?
Not in this context, because the court applied the wrong legal standard. We submitted, in support of our expert, business records. I believe in Canavan's case, Lanigan, every case hereafter, this court has said there are varieties of ways in which you can establish methodology or reliability. Here, Your Honor, it's important to understand that this virtually involves no scientific studies. If that point is not clear, we analyzed the universe of records. There is no margin of error. We counted every single one.
It analyzes the methodologies your expert used or chose not to use in determining whether they were reliable for purposes of admissibility on the point. I mean, it strikes me that at the end of the day, there were at least two experts that testified. The judge had an opportunity to examine both of them. And why isn't it within the judge's discretion, as he carefully went through the testimony of the expert, to exclude your expert?
The judge lacks discretion not to follow the law. We presented business records. There is absolutely no analysis here as to whether or not our expert could rely upon the business records.
Well, but wasn't, I thought, and I could be wrong, but I thought that what the judge was saying with respect to those business records he wasn't saying you can't rely on these business records because they are not valid or they have too many mistakes in them. I thought what he was saying is those business records, accepting them as accurate business records, don't allow the inferences that your expert was drawing from them. Wasn't that what he was saying?
No, Your Honor, he does say that in part. And let's get back to the evidence, because if he had followed the four-prong criteria set out for business records, you would see that they do. The policies and practices and testimony all say that that is exactly what the records are used for. And if I could cut to the chase right away, let's get to the heart of the issue. We deposed Wal-Mart's person most knowledgeable about those records. What are they used for? This is the chief corporate officer in this litigation on this issue. Quoting from RA 002488, Teresa Cook. She's the chief of the audit department. We asked her, how do you know at Wal-Mart that when you monitor are people missing meal and rest breaks in violation of many laws and its own policies? Here's what she says. Question. When I said other than the exception reports, these are some of the reports in Wal-Mart's corporate use daily that we provided to you. Question. Are there any other records which would indicate whether associates were missing meal or rest breaks? You said yes, the time clock archive reports. That's one report we provided to your court. Going on. Question. How would the time clock archive reports indicate if associates were missing meal or rest breaks? This is what the person most knowledgeable says on this topic in this litigation. The time clock archive report shows you for the entire time period what each associate worked, when they clocked in to start their shift, when they clocked out for their lunch break, when they clocked back in, and when they clocked out to go home for the day. That is what Wal-Mart uses these records for. That is what we use them for here. It is not a methodology. This is their regular practice, not in theory. We also proved that this is what they do in their regular course, up and down the corporate ladder. Everyone is saying what we're saying. Walmart's experts, or excuse me, their corporate responsibility persons most knowledgeable had an opportunity to support their litigation defenses, as did their store managers and their own associates. They don't. That's what we tried to do in our briefing. Every single person supports our view. It is the policy. Not only is it the policy, it's our practice. Everyone is doing it.
Ms.
All
Burton,
they've done
I
here.
have a question. Given that, if you're correct, I thought I read in the defendant's brief that most courts ruling on similar issues or issues similar to those in this case have ruled in favor of the defendants. And how? What is your response to that?
It's incorrect. I mean, two states have already tried these cases. We've had 2 jury trials, 2 judge trials. And
I think the defendants distinguish those cases.
Your Honor, let's talk about that. They're not distinguishable. In California, I was one of the counsel of record there. It was a meal break violation under PDO 7, the very same issue that we had here. They did not have rest breaks for additional reasons, and we could get into that, but it's probably not relevant.
I tried to add up the states, and the calculation I got right or wrong is 8 have ruled sort of in your favor and 10 have ruled against you.
That's probably a fair approximation, Your Honor, but what we think is important, most of those rulings, and again, I think this court has to decide for itself what the record shows. This is the highest court to really look at a full record, and I think that's critically important here.
Curiosity,
when we're throwing.
I don't want to throw you off your argument, but have there any criminal prosecutions been initiated against these people for what you claim they've been doing by attorney generals or other? These are crimes, are they not?
Not as of yet, and we have been in communication and we have been working with the Attorney General, and I think as referenced in the amicus brief, they're understaffed. They don't have the resources. I don't think that's any reflection on the merits. The reflection on the merits is in the 2 jury trials, 2 separate court proceedings. Everyone is finding knowing and willful wrongdoing. So to add it up, Your Honor, I don't believe that the record shows that courts are rejecting this. But if you really want to look at those decisions, many of those were really originated prior to 2003, before we started to receive a lot of the evidence that we're relying upon today. Some courts have taken a different view. The Iliadis court just came down on certification in our favor. The Dukes and Ninth Circuit on a sex discrimination case is ruling in our favor. I think really the tide recently, based on the evidence that everyone is finding, is saying that this is very valid. But more importantly,
Excuse me, what is very valid?
the merits of the case, that this is going on. People have had 3-month jury trials where Walmart has free to bring in any witness it wants. We have judges making independent determinations of knowing and intentional wrongdoing. The evidence here shows the same. I mean, when have you seen corporate admissions, more than one, to the existence, policies, acknowledging this is going on, internal memos, and then what do they do? They covered it up.
What do we do about this? You've got a class, you say, is 67,000 employees.
Correct.
How many in that class have not been injured? What's your estimate of how many in that class have not been injured? How over-inclusive is the class?
Zero.
So every member of the class
Absolutely,
has
Your
been
Honor.
deprived of one of these.
Absolutely. And what we've alleged, that this is a systemic policy. Everyone, just like in the sex discrimination cases, is subjected to the overarching policy. We put on significant evidence to show it's uniform. This is how the system is designed. This is not errant rogue behavior.
I'm sorry. Are you answering my question that your evidence is that every single member of the class was deprived of a meal break, deprived of one of the things you claim is wrong?
Actually lost money, I think is
actually
what the
lost
question.
money.
If you're asking for direct injury, our evidence does show that everyone missed a rest period.
Well,
now,
wait
if
a
you
minute.
break
Is it undisputed that meal breaks are not compensated?
It is disputed, and I would
That's
say why.
disputed.
Because their own policy provides for remedy. If it's interrupted, you are to get your pay for that half an hour of duration. If you got a portion, or if it's interrupted, or it's missed, their own policy says that you should receive an additional break later, plus we're going to pay you
But
for
I
that
think
time.
what I
If it's interrupted.
What I think you're arguing is that, yes, every member of the class has been injured in terms of monetary loss in one way or the other, even if it might be difficult to differentiate amounts of money, that's really a management issue for the judge dealing with a class action, which can be done by reference to masters, breaking it into subclasses. We've all done this in the trial court when we were trial judges, that is not a drawback to proceeding with the action.
Your Honor, my time is up. May
You-
I
of course you-
respond?
yeah,
Thank
you
you. You do make our argument, but I do want to clarify. Everyone has been injured. The rest break is rampant. Their own documents show it. Everyone suffers that. If you parse it out in the way, did everyone get a 1-minute clock out? No, not everybody did. But again, our allegation is that they're subjected to some sort of shortchanging of their earned benefits. This is supplemental wages. These are not just willy-nilly. This is a compensation package. This is a wage. It's called supplemental income, and they are entitled to it. Everyone suffered that.
Your evidence on that is that everyone, if you look at everyone's time cards, there won't be a break entry on them or something? I mean, what is
No,
the evidence that everyone
Our
is at a
expert's
loss?
analysis suggests that everyone was deprived of a rest period. However, Your Honor, post-2001, as you know, or you might understand from our records, we cannot tell post-2001. We believe everyone suffered that same thing.
And
but
you establish that only because what you say is if you didn't clock out for a rest period, you didn't get it.
not
right?
post-2001. They didn't keep the records.
Pre-2000. If you didn't clock out for a rest period, your expert says that means you didn't get it.
Our expert doesn't say it. The evidence shows it. Again, our expert does not go in and make this up. The evidence shows that that is what these records were maintained for, and they did not get them. Their own corporate policies show that if it's not in the records, you did not get one. What we're talking about here, are there some errors
Wait a
that
second.
somehow
There were a lot of affidavits presented, as I understand it. I certainly haven't gone through the entire record, about people that said, no, we didn't clock. I mean, it's a pain in the neck to clock out for your clock in and out and for your rest breaks. We didn't walk down to the clock and do that. We just took 15 minutes, smoked a cigarette.
Your Honor, may I address that? It doesn't say that, and I'm glad you raised that. We have gone through every single one of them, and we have identified them for you, just lest there be any confusion. There are 28 affidavits here talking about did they follow policy or didn't they. 25 of them said they did every single time. And they said when they didn't, they followed policy to correct it. We've shown these policies, it's vetting. There's checks and balances that are followed, maintained. And this is not done for our benefit. It's done for Walmart's. They're trying to make sure that no one is stealing corporate time. So they did police it. There are a few, Your Honor. There are 3. And if you'd like, I'd give them your names. There are 3 that said on occasion I didn't do it. To err is human. There are going to be some mistakes in these records. We went through over 1 million of them. And for 3 people to somehow say that this is not a regular course of conduct or a policy is a travesty of justice. Thank you very much.
Thank you, Ms. Burton. Mr.
Thank you,
Watsfield.
Your Honors. I'll try to move quickly. The trial court's decision that meal breaks have no value was an error. The second point that I'd like to address is that the trial court's finding that as a matter of law that Walmart's most egregious conduct should not be allowed to be brought before a jury was also an error under the theory of fraudulent
Can I attempt
concealment.
to get one claim out of the case? The claim under the wage statute, I think it's Chapter 148-100,
Yes.
which the judge granted, I think, summary judgment on. You don't seriously pursue that one, do you?
Yes, Your Honor, and I'll
I mean,
tell you.
that provides only for a criminal penalty. It doesn't seem to create any private right of action.
Well, I think under Ludlow, I think that actually, in my opinion, that this is the quintessential situation for the court to step in and create a just cause. This particular statute was clearly enacted for the benefit of the employee. There's no reasonable argument.
But it's a criminal statute, and that's why I said they can go, if they want, over to the Attorney General, District Attorney, whoever enforces these things, and criminally prosecute these people, assuming the DA and Attorney General finds the proof is there. But where does it create a private right of action?
Well, I think that it's well established under this court's law and also under the United States Supreme Court law, Bell versus Hood, that where a statute is violated, that there should be a civil remedy. I think that it's also as a matter of policy, Your Honor, to have a statute rendered meaningless that was clearly intended to benefit a class is wrong.
Not rendered meaningless. It's enforceable by the Attorney General as a matter of criminal law. That's hardly meaningless.
Well, I think that the fact of the matter is that Walmart's own expert documented and admitted to 1 million violations.
Sounds like a big criminal case.
Well, we've been to the Attorney General a number of times, and we haven't seen a criminal case. And even if there is a criminal case...
Maybe they use different criteria than you're using.
Well, they have a beyond a reasonable doubt statute. And I think that why should people be denied the right? Why should the workers be denied the right to bring their own cause of action?
I don't want to take you
not
off your
criminal?
argument. Your basic contention on that claim is that, yes, when we look at the cases, we'll find that that statute does create a private right of action. So we got to look at the cases. So now we're back to the other points.
I can also help to clarify a point, because I think I'm getting a feel here. On the one sense, the $300 to $600 fine, which we advocated could be used as a benchmark, could seem ridiculous. Why should someone come in, an employee, and be able to bring forward a $300 to $600 fine? On the other hand, giving them no remedy, giving them a $0 remedy, is equally as ridiculous.
Well, you got your civil action, and that's what we're talking about, all these other claims.
There's no remedy either in law or in equity for the missed meal breaks. The judge in the trial court first threw out the legal claim and also threw out the equitable claim. If there is no claim of law, which we think that there is, we think that you should
I
go
thought you
under
said this is a
levy.
breach of I thought this is a breach of contract claim. They on the contract, isn't it your argument that they should have gotten a meal break?
Yes. He
So-
said that he cannot, the trial court was very clear that there's no assessment of damages that he can come up with in tossing the claim out. He said they worked the half an hour, so they got paid for a half an hour. And so that he was unable to formulate an economic loss, and therefore just deprive the workers of any right in law or equity.
What you do in these circumstances, it seems to me, is you notify the Attorney General that the employer is violating the statutory rights of the employees to a half-hour meal break. And the Attorney General comes in, and presumably they have a whole division over there that does this, and they determine whether that's happened. If it has, they correct it.
And I'm glad that you brought that up, because under the Maloney case, this court has previously recognized that the intent of a statute is perverse. That's when this court should step in. Now, what we have here is a statute. We all understand to benefit the employees. Under the criminal statute, the state gets $300 to $600. The employees get nothing.
No, they get
Nothing for the past. They get nothing.
No.
And if the employee is no longer working there, what do they ever get?
I didn't understand the point you're making.
So
I understand it now.
Apart from the criminal statute, what is your theory, what is your alternative theory in a different count as to a deprivation of value for the loss of a meal break?
Well, in this
where the employees have already been paid for that period of time.
In this particular case, we're very fortunate because there's a liquidated damages clause in the contract. There are also corporate admissions, you might call them, corporate records up and down, corporate policies up and down. The record is replete with Wal-Mart's position. Wal-Mart's position is pay them for the time lost, pay them for the half an hour.
But I thought you just said they did get paid for the time lost.
Well, no, they got paid for working through their rest break. They got paid for working through the lunch break. They didn't get paid. What Wal-Mart said is you did get the half an hour in compensation for the break that you missed. The trial judge said, look, you worked, you didn't take your lunch break, so what? You still got paid. What Wal-Mart says is if we take away your ability to eat your sandwich, we're going to give you a half an hour's worth of pay.
An additional half hour's worth.
An additional half an hour's worth of pay, which is reasonable. I mean, this is not an easy job. These people have worked very hard. They're understaffed, and they should get a chance to take a break and eat a sandwich.
If you work an 8-hour day, hypothetically, you're entitled to a half hour for lunch. If you have to work through your lunch period, you get paid for working that lunch period.
You get 8.5 hours.
8.5 hours.
You then get 8.5 hours. Are you saying you're supposed to get 9 hours?
You're supposed to. That never happened.
Wait
They
a
never got
minute.
the half hour.
Let me finish.
Okay, sir.
Are you supposed to get paid 8.5 hours plus another half hour for having lost?
That's debatable because they say you get a half hour extra pay plus you get the break. So they sort of had it internally where they ostensibly, through their own records, would punish themselves. So you get the time you work, then you get a half hour pay, and then you get your sandwich.
Okay.
Thank you.
That's one way of looking at it. But point is, in this particular case, you're never going to get an...
Your time is up. Thank you, Mr. Bonsignor. Good morning, Mr. Eskridge.
Good morning, Chief Justice Marshall. May it please the Court. My name is Charles Eskridge, and together with my co-counsel, Donald Frederico, we represent Wal-Mart stores in this action. I'm going to address the Daubert and Lanigan findings of the Court. Mr. Frederico is going to address the issues pertaining to the certification decision. I was preferring to rest on our brief for the summary judgment rulings of the judge, but I do want to clarify one point about compensation for those meal periods. There is not, this is in the briefs, there is not a policy or something that is part of the supposed contract about the meal periods that would say that if you work through your meal period, you get an additional 30 minutes of pay. Instead, what it said is if a meal break was interrupted, you would be given the ability to take another 30-minute lunch, but that would itself be unpaid. There is no way to look at the situation where there is not full pay for all time that's worked that day, and it is clear that meal periods were unpaid in all respects.
So if you had to work through your scheduled meal period, you would get another time to eat your meal. Would that be at the end of the day when you went home? Or?
Well, many employees chose to work through lunch, yes, for various reasons, so that they could leave early, so that they could actually get the extra half hour of pay instead of taking a 30-minute lunch.
That's debatable whether they chose, isn't it?
I'm sorry?
Isn't that debatable whether they chose?
There is evidence that was submitted that, there are affidavits, there were testimony that yes, many associates chose to work through because they would want to leave a half hour early to go pick up their kids after school, because they would like to work through the lunch and get paid for 30 minutes instead of taking 30 minutes for lunch that they didn't want.
Yeah. Mr. Eskridge, can we agree that the plaintiffs have adequate proof that from top to bottom, the top corporate executives down to store managers and others, they knew these practices were going on and they covered them up?
No, Your Honor, we wouldn't agree with that. In fact, what is
can
interesting...
I read you the deposition testimony of the manager, the employee in the store 2 miles away from me?
You may if you'd like to, but if I may
You're
respond
familiar with
to
it,
the
and
broader
she says,
point.
in fact, something that everybody at the management level, regional, district, and so forth, knew was happening, yes.
If one looks at the corporate documents from up above, the policy is clear that management in Bentonville wants every employee to be paid for every minute that they work. When one looks at the evidence that plaintiffs bring forward as to their waiver argument, what you see is management trying to ensure that, in fact, meal periods and rest breaks are taken if the employees want to take them, if they are not deciding on their own not to take them.
Is what you're trying to do, are you trying to show that there's a policy overall that that the company wants everybody to be paid for every minute, but that somehow this isn't being enforced at the local level?
There is, Judge Murtaugh in his ruling was very clear about this. What Dr. Shapiro failed to do in his methodology was to verify whether or not the timekeeping records were accurately reflecting what they were set up to reflect.
I have a question about that. The attack that the plaintiffs make, or what their argument is that you are now saying that these payroll records, which are your business records, which you use for all sorts of purposes, tax, paying people, paying taxes, whatever, unemployment compensation, that you are now saying these records are inaccurate.
Well, it depends on which claim we want to talk about, because as to 1 minute punch in inserted meal periods, it is the plaintiffs who are asserting that they're inaccurate, that in fact what is reflected in those records is not something that actually happened that day. And it shouldn't be forgotten that the situation that we have...
I thought that's what you're claiming as to a lot. You're saying the time records are not accurate because people don't punch in and punch out like they're supposed to. But yet you use these time records to determine their pay and to determine taxes.
As to rest breaks, let's consider the missed rest breaks, that claim. Rest breaks are paid whether or not the break is taken, whether or not an employee swipes in or out for the break. And there were witnesses who testified at the hearing. There are many affidavits that were submitted about the fact that associates would not swipe in and out for their breaks, that managers, when they followed up with them, they would do so many times orally, they would not make them go back and correct the time record because it did not affect pay at the end of the day. Plaintiffs put in...
You pay them for the breaks, whether they're on their card or not.
Rest breaks are paid, so whether or not they're reflected in the record is not the question. Plaintiffs put in evidence of coaching forms, supposedly to show that the records are accurate because the managers are out there making sure that the associates correct their time records even as to rest breaks. Judge Murtaugh looked at that as evidence that coachings didn't happen, the evidence showed, until there were several violations by a particular associate. And then a particular coaching form that might be there could account for many different periods where the person didn't swipe in and out for the rest break. None of those would go back and be corrected in the record. And so for associates who, by their own admission, are not swiping in and out for their rest breaks, Dr. Shapiro would be looking at that and saying, that person didn't get their rest break and is entitled to it. But under the coaching forms themselves, they took their rest break. They just didn't
But
swipe for
your
them.
argument is that it doesn't matter whether it shows or not because they're getting paid, period, for it. Is that what you're saying?
They are getting, well,
Yeah.
for rest breaks that are taken, obviously, they're still paid for that time. For rest breaks that are not taken, they're not paid for that time. But that's not our argument. What we're saying is that Dr. Shapiro's methodology, when he's trying to look at this, is not linking up whether or not the time records. He's ascertaining, did 3 hours pass on a shift, and is there a swipe record for a rest break? If that didn't happen, then a rest break, he assumes, did not occur, and therefore
Right.
there's liability. But
That's
it doesn't
what,
answer
when
the
I said
question.
before that the judge is saying that the,
Records don't support the inferences.
that the records don't support the
Yeah, and
inference
is
that
that
we're
based
And it-
on the testimony of your expert?
I'm sorry?
Is that based on the testimony of the expert you provided?
No, it's not. I mean, it's based, she, of course, yes, I mean, testified to that fact, but what she was basing her report on were the affidavits, the deposition excerpts that we put in, and before the
Mr.
judge, we also
Eskridge.
had live testimony.
Mr. Eskridge, let me ask you this. If there was an obligation to provide for rest breaks,
Yes.
in other words, in the language that you've been using, an employee would be paid $100 for an 8-hour period, which was to include a half-hour break. And if the company was aware that, for whatever reason, people frequently didn't clock in and out when they were going on a 30-minute or 15-minute break,
Yes.
and if there is substantial evidence either that employees felt they should not go on their breaks because they felt coerced in some kind of way, I hesitate to use that word, but they felt forced in some kind of way, or the law says that if you work through your break, you should be compensated. And there's substantial evidence that this happened repeatedly. Whose burden is it to show that the minute-by-minute timekeeping records that the company had in place, knowing that, and I take it that this, at least with some of the deposition testimony, that everyone knew that employees were not taking breaks or not clocking in or not clocking out, whose burden is it to show that?
I think that if by law or by statute there was some burden that was placed on an employer to keep accurate records in that regard, and that was something that was going to be looked at to ascertain as a starting point whether or not full pay for the day's work had occurred, then perhaps Ms. Burton's argument about the reliability of business records might carry some weight. But that's not, in Massachusetts, as just to the rest break claim, there is not a law requiring, as Judge Murtaugh points out, there is not a law demanding that rest breaks be given. And in fact, they're pursuing only a contract claim.
No, I wasn't. I was thinking rather in terms of how not. I know there's not a law that requires that, but when you're looking at burdens within class certification,
Yes.
where you have, let's just assume that you have evidence of rampant conduct. I'm not saying it's correct or incorrect, but evidence of rampant conduct, namely that repeatedly and systematically and at all levels, people were working through their breaks and not being compensated or not given their breaks. Can't the judge, or shouldn't a judge, take that into account, because it's going to be all but impossible to take individual A, and I'm not talking about, shouldn't the judge take that into account?
I think that the burden in all respects is going to remain on the plaintiffs.
The burden is going to remain on the plaintiffs, but can't the plaintiff satisfy that burden not by individual clocking in and clocking out, but by the kinds of claims, sworn testimony that we have here?
No, Your Honor, I don't think so. I believe I would direct you to Judge Murtaugh's opinion. I believe it's at page 47 or 48, where he goes into the evidence and the testimony that plaintiffs put in. I mean, he fully considered what they brought forward, and he said, you're still not showing me something that's representative as to the class as a whole. You're still not showing me that, looking just at the time records, you're going to be getting to something that reliably shows damages, to any particular person. And as Justice Cordy had brought up before, in viewing that evidence, that is going to be subject to abuse of discretion at this court. And Judge Murtaugh himself questioned Dr. Shapiro for an hour on the morning of July 28th during the hearing, 2006. Questioned him for an hour. And those types of credibility decisions, I believe, are entitled to deference.
But is there a company policy that requires employees to check in and out for a meal break?
Yes, there is.
Yes.
So, with respect to a burden of proof, why don't company records? They're admissible, aren't they, to show that because the person did not check out, they didn't have a meal ticket, at least for that purpose?
They are admissible, and we are not saying that the records themselves shouldn't be considered. The question always remains, and I'm here addressing the Daubert and Lanigan issues. The question remains, is the methodology that Dr. Shapiro employed to show that breaks were actually missed reliable? He looks at the record, and all he can ascertain is that the swipes aren't there. It is the analytical gap described in the United States Supreme Court case, the Joyner case. It's simply his say-so, his assumption that every missed swipe equals a missed rest break. And there's not evidence that supports that inference.
And I know you're focusing on Daubert and Lanigan, and I'd like to hear just a little more about it. So from your perspective, as we look at Judge Murtaugh's decision,
yes,
excluding this expert testimony, what are the most important things we ought to be looking at, and what's the standard we apply to that?
In deciding whether or not to, in considering the exclusion of his opinion?
Exclusion of his testimony.
Well, in all instances, we're looking at the reliability of him transforming what he's able to view in the records with the conclusion that he is attempting to draw.
Well, go ahead.
All right.
As to rest breaks, when he concludes that there are no swipes, he concludes that a rest break has been missed if there's not a written TAR, but the evidence shows that employees did not always swipe out for their rest breaks when they took them. When they discussed them with their managers afterwards, they did so orally and didn't go necessarily file
So that's the most important gap. That's the thing that the judge focused on.
As to rest breaks.
Why do you need an expert for that?
Yeah.
Yeah,
Why is that
why do you
susceptible?
need an expert?
It's a matter of simple arithmetic and business policy, business records.
Well, the important issue here is that the judge excluded the expert.
Well,
and on that basis,
As to
Forget the expert. Why isn't the documentary evidence alone sufficient?
And then it would be your burden to show that it isn't right.
For Associate A in 2002, who is showing up in Dr. Shapiro's records as having missed a whole bunch of rest breaks, and for which Dr. Shapiro is now concluding he was always forced to work through his rest breaks. When we look at Dr. Shapiro's reports, we can go talk to that associate, we can go talk to the manager, and the manager would say, the guy never swiped out for his rest breaks. I talked with him about it. Or,
why is that a question of expert opinion?
Yeah, are you confusing weight with admissibility?
I'm sorry?
Are you confusing weight with admissibility?
No, I don't believe so, Your Honor. As to why is an expert needed?
Yeah.
It is
all you need is somebody
expert-
that can read the business records and add them up. to show which ones showed a missed lunch break. It's
But-
not
but
a question
that's
of...
not what it's showing, Your Honor. That's
Well,
the
that's what
point.
you
But-
say.
but
Exactly.
you're- but it's
So
your
that burden is on you to show that your
Yeah.
business records are not accurate.
Isn't it the corporate policy that people take their, not just that they take their rest breaks, but that they swipe in and out? Isn't that the corporate policy?
Yes, it is, Your Honor.
So why is it the plaintiff's burden to show that these records aren't purporting to be what they need to be? That's your policy, that people should swipe in and out.
Yeah, all you need is a wheelbarrow. You come in, you drop all the records in front of the jury, and somebody gets up and testified that I read all these records and there's no swipes for missed meals.
Mr. Federico is going to address how this plays out in the certification context.
Can I ask you one last thing, because you're running over, and I know
Yes,
you've
Your
got a
Honor.
lot of questions. Did Dr. Shapiro's testimony get admitted in California and Pennsylvania?
An interesting question. As to California, okay, there was a trial there. That judge refused to certify every contract claim and did not go forward on those. The only claim that went to a jury was a state statute claim, California law,
Yeah, but did
specific to
Dr.
California.
Shapiro testify? That's the question.
And as to, my recollection is that as to that, the state law says itself that there can be no waiver of meal periods. And in
Okay.
that context, I don't know whether Shapiro testified, but if it was not Shapiro, it was another expert like him that testified.
Okay.
But in the context of that statute and what its requirements were, the court allowed that to go forward. But none of these types of contract claims, none of the rest break claims, none of the 1-minute punch claims, none of that went forward in that action.
Okay. All right.
Thank you, Mr. Eskridge.
Thank you.
Mr. Federico?
Good morning, Chief Justice Marshall, members of the court. I would like to address primarily the issues of predominance and overbreadth as it pertains to class certification. Before I start, though, I'd like to preface my comments by reminding the court that we have not presented our merits case yet in this case. The case never got to that stage. We vigorously dispute plaintiff's allegations that there was widespread violations of company policy or of law with respect to these issues. And I would ask the court not to prejudge that issue based on the incomplete record that is before it.
Well,
Now-
wouldn't you at least agree they appear to have a prima facie case of corporate malfeasance?
No, Your Honor, I would not.
I mean, what I read by the regional vice president
The
is
evidence,
incorrect testimony?
no, the evidence in the case, Your Honor, is that the company had policies to ensure that associates got all of their breaks and were paid for all time worked. Now, there is also evidence that there were, in some places, at some times, individual managers who from time to time deviated from that policy. And whenever, if you look at the evidence that the plaintiffs rely on in their brief, the evidence is evidence that every time an issue was brought to corporate headquarters and to corporate officers, the response was to try to stop these individual managers from engaging in practices that were against company policy.
So are you arguing that if the individual managers, regional vice presidents and so forth were doing this, but the people at the top were trying to stop them, that Wal-Mart might not be liable?
It's not a question of liability, Your Honor. It's a question of not whether those claims could be advanced in an appropriate case.
Okay.
The question is whether they can be advanced in a class action. And that's the only issue really before this court. And the issue that was addressed by Judge Murtaugh related to the issue of whether common issues predominate over individual issues under Rule 23. Because the plaintiffs do have the burden. In order to say, not only do we think our claims have merit, but we think they're appropriate for class treatment, they have the burden of showing that common issues predominate over individual issues. They may have identified some common issues in their brief, but the problem with this case is that there are enormous individual issues. The Rule 23 and the predominance standard really must be enforced, and the plaintiffs must be held to their burden. I'd like to quote just very briefly from the advisory committee notes
to the federal rule 23b3, which stated that the rule was intended to cover cases, quote, in which a class action would achieve economies of time, effort, and expense, and promote uniformity of decision as to persons similarly situated without sacrificing procedural fairness or bringing about other undesirable results. In this case, and in cases like it, where there is a predominance of individual issues, certification of the case would bring about procedural unfairness to the defendant and would bring about undesirable results.
Why isn't that a question of management for the trial judge when, if liability is established, to then break the class down into subclasses, maybe appoint an auditor, you know, do the various use the various techniques that judges use to manage these cases?
I have both a legal response to that and a factual response to that, Your Honor. As a legal matter, Massachusetts Rule 23 does not permit that. There is no provision in the...
It doesn't permit opt-outs, but it does permit subclasses.
There is no provision in the language of Rule 23 that permits subclasses, and in fact, if you extend the logic of the court's decision in Fletcher, where the court said that Rule 23 does not permit class certification of individual issues because it was not written into the rule, that would also eliminate the need to...
Federico,
No, you're not
I think
certifying.
judges
Yes.
certify subclasses all the time.
Yes,
Well,
they do all the time. They're
Your Honor,
certifying.
all I'm doing is trying to apply this court's decision in Fletcher to that question, and I think an extension of Fletcher would say that the rule does not permit it. Even if the rule permits it, however, Your Honor, subclassing in this case would not eliminate the need to resolve the individual issues. At some point in time, a finder of fact, whether it is a judge, a jury, or some special master, would have to make the determination as to whether Wal-Mart has injured each of the class members. Whether the records alone, as Mr. Eskridge has explained, do not establish harm to everybody.
That happens all the time. We get letters in the mail that your insurance company or somebody else, you know, they're subject to a class action, and, you know, if
But-
you're owed anything, submit proof. If not, you're going to get $25 or something like that.
But, Your Honor, I think it's important to keep in mind what this case is not. It is not like those cases. This is not a case where the plaintiffs complain that there was a uniform policy uniformly applied, and therefore the common issues predominate, and it can all be dealt with as
They
one
are
collective
making that
action.
claim, are they not? That up and down the line, all 67,000 of them were subject to a corporate policy.
Well, the only evidence of a corporate policy in this case are the policies that say that employees shall be paid for all time worked, that employees shall take their meal periods, and the issue in the case is not whether there was a corporate policy that harmed people, but whether individual managers in the individual stores were violating that policy
At least
on
up to the
individual
regional vice
occasions.
president level.
I'm sorry, Your Honor,
I'm misreading that. But
I don't have the complete testimony in front of me, and I don't recall exactly what he said. However, I think it still holds true that while there may be acknowledgement at the corporate level that there were problems in some of the stores with some of the managers at some of the time, that doesn't prove that there was a class-wide uniform policy that was depriving people of pay or that was depriving people of their breaks. And the problem with this case is it's not like those cases. It's not like Anderson versus Mount Clemens. It's not like a misclassification case which do get certified frequently and which raise the issue as to whether the policy not to treat somebody as a non-exempt employee is right or wrong. That's
So
not
when
the
your
issue.
sister said early on, this is not errant rogue behavior, it is systemic, everyone suffered, you disagree.
We certainly disagree with that, Your Honor. And let me bring some facts to the Court's attention, if I might. These are in the page 21 of the plaintiff's brief, and this goes to the issue of whether everybody in the class has been harmed. And I'm going to use Dr. Shapiro's numbers, which we think are grossly inflated and flawed methodologically, but let me just use them, if I may. Even using his grossly inflated methodology, Dr. Shapiro counts 13,572 inserted meal periods that he says have resulted in harm to the class. Now, first of all, again, that's grossly inflated.
He even says that he intends to make additional deductions. And that sounds like a large number, but that should be taken in context that he's looking at 6 million shifts. The point is that with a class of 67,500 people, if there are 13,500 inserted meal periods, that means there are at a minimum 54,000 in this people in this class who never had an inserted meal period. You can do the same analysis with the 1-minute clockouts. The number he comes up with is 21,383. Again, it sounds large, but he's looking at 11 million shifts. You subtract that from the total number of class members, you have at least 46,000 people who were not injured by the 1-minute clockout and yet are part of this class. You
Mr.
look at the-
Federico, I hate to interrupt you, but your time is running over, and if there are no further questions, I think we need to move ahead.
Thank you, Your Honor.
Thank you.
If you'd like to just submit a brief 16L, I don't think that I did Justice Courtney justice in just saying there were only
Ms.
3
Burton,
affidavits.
our rules are very clear that if whatever you're going to submit falls within what the rule is designed to do, you may do so. And obviously the Wal-Mart can respond. I will take a short break.